Hi, my name is Joe Frick, and today we're going to be going over paragraph 3 of your divorce petition, which is where you tell the judge why you want the divorce. Before we get into the grounds, I figured I would explain the difference between fault-based and non-fault-based divorces. First, I'll go over non-fault-based divorces, which is essentially irreconcilable differences. If you put irreconcilable differences in paragraph 3, that means you don't have to prove anything and the court will just give you the divorce because you want it. The fault-based divorces is the other 7 reasons that you can file for divorce in Idaho, and in each one of those reasons, you have to actually give the court evidence to prove that the reason you want the divorce is valid. The 8 grounds that you can file for divorce in Idaho are adultery, extreme cruelty, willful desertion, willful neglect, habitual intemperance, conviction of felony, permanent insanity, or irreconcilable differences. Now let's go through those each one by one. Let's start with the most common reason why people ask for divorce, which is irreconcilable differences. Now, this is one of those no-fault grounds. You don't have to prove anything to the court. All you have to do is put no irreconcilable differences in paragraph 3 of your petition, and you just have to tell the judge that you want a divorce, and they will give it to you. You don't have to prove anything. The burden that you have to show to the court is essentially just testimony saying that the marriage is irretrievably broken or something similar to that. Before we get into the fault-based divorces, let's talk about what the burden of proof is. To what degree do you have to prove these allegations to get the reason for the divorce that you want? So in Idaho, there's essentially 3 different types of burdens of proof. Essentially, there's preponderance of the evidence, and that's essentially a more likely than not standard. You have to be above 50%. 51% will get you there. The next one is clear and convincing evidence. Now, this is higher than 51%, but it's lower than the beyond a reasonable doubt that you have to prove in criminal cases. In family law cases, there is not a case that has the beyond a reasonable doubt standard as what you have to prove to get your grounds for divorce. But in a clear and convincing evidence standard ground, you have to prove it in a way that the judge is going to have a firm belief that this has actually happened. So there's not an actual percentage as far as that goes, but we're looking at the 70-75%. It has to be a firm belief that these things has actually happened. First up on the list of fault-based divorces is adultery. With adultery, you have to prove that your spouse had sexual intercourse with another person, and you have to prove that on the clear and convincing evidence standard. In order to prove adultery, you can use photos, you can use videos, you can use audio recordings, you can use text messages, you can use hotel receipts, essentially anything relevant that would show that it's more likely than not that this person actually did commit adultery. You can use that evidence. However, what you have to keep in mind is text messages usually aren't enough unless they're a straight up admission that that actually happened. Once you get into the divorce case, you can actually ask them to admit that they committed adultery, but that's a little further down the road. Next up is extreme cruelty, which you have to prove with preponderance of the evidence, which is just above 50%. However, extreme cruelty is extremely hard to prove. In order to get extreme cruelty proven in court so that the judge will order that the divorce happen because of extreme cruelty, the burden is only a preponderance of the evidence, but the facts of the extreme cruelty have to be pretty severe for the judge to come up with a determination that extreme cruelty has occurred. So when you're thinking about extreme cruelty, you're going to want a lot of documentation because you're going to need that to prove that the extreme cruelty, physical harm, and mental anguish actually happened. Next up is willful desertion. Now you have to prove this by preponderance of the evidence, and what you have to prove is that your spouse has abandoned you up to a continuous 1-year period. And what you have to prove is documentation showing when they left and that they still have not returned. This is not a very common ground for divorce that people use. Next up is willful neglect, which is essentially your spouse intentionally not giving you basic necessities when they have the ability to do so. You have to prove this one by preponderance of the evidence. Next up is habitual intemperance. This is also not a very common ground for divorce that people allege. What you have to prove with habitual intemperance is chronic alcoholism or very bad substance issues that is affecting the marriage. Now you have to prove this one by preponderance of the evidence. Next up is felony convictions. If your spouse has been convicted of a felony, the court will grant you a divorce based on that ground. Next up is permanent insanity. Now, this is also not a ground that's used very common. It does have to be preponderance of the evidence, but the reason is the person has to be essentially committed for 3+ years. So permanent insanity is not a very common ground for divorce. Let's talk about some of the practical realities of what you're going to be putting in paragraph 3 for your grounds for divorce. If you choose a fault-based divorce over irreconcilable differences, you actually have an affirmative, a positive duty. You actually have to go out, get the evidence, and provide it to the court so that they're satisfied that the grounds for divorce is valid and the reason that you said you need the divorce is true. All that takes time, money, and effort. So if there aren't any factors that would lean towards you getting more of a custody or more of the division of assets because of the ground for divorce, it's mainly beneficial for you to be doing the irreconcilable differences. And this is because the judge will give it to you without having to prove anything, and you don't have to go out and get the evidence. And if you have an attorney, you don't have to pay them to do the testimony to put that in front of the court for you. So irreconcilable differences is typically a lot less expensive than the fault-based divorces. However, some of the fault-based divorces, if you are successful in proving them, can help you in possibly the alimony or the spousal maintenance issue if that is present in your case. The reason that it may affect your spousal maintenance or alimony decision is because the grounds for divorce is one factor that the court can take into account when they're trying to figure out how much the other person should get paid and for how long. If you're going through an Idaho divorce and you're trying to figure out which ground for divorce you're trying to put in paragraph 3 of your petition, you gotta think long and hard because it may or may not affect other issues going on in your case.